You may be seated. Court is now in session in the matter of Ali bin Haji Ghazali and Hajah Alisha binti Heng. Are the parties ready to proceed?
Yes, Your Honor. May it please the Honorable Court, my name is Aina Mardia, appearing as a senior counsel on behalf of the plaintiff Ali bin Haji Ghazali.
Defense counsel will now present their opening statement.
Much obliged, Your Honor. My name is Shahida Tushifa, appearing as counsel on behalf of the defendant, Hajah Alisha binti Heng.
Very well. Before we proceed, I would like to remind all counsel and parties that this case involves important questions regarding the validity of wills made under Muslim law, especially concerning testamentary capacity and the proper execution of wills in accordance with both Islamic principles and local statutory provisions. It is imperative that all evidence and submissions be presented clearly and respectfully, as the outcome will affect the distribution of the estate of the late Haji Ghazali. Counsel, you may now proceed with your opening submission.
Much obliged, Your Honor. Our case hinges on the undeniable final wishes of the late Haji Ghazali, documented in his will dated February 24, 1968. The content he possessed full testamentary capacity at that time, explicitly appointing my client Ali bin Haji Ghazali as sole executor and granting him the entire estate. This is his true and final testament. May I call upon the plaintiff to stand? Please come forward. Mr. Ali, please state your name and recount the events on February 24, 1968 concerning your father's will.
Your Honor, I'm the eldest son of the late Haji Ghazali. On 24 February 1968, while gravely ill at Johor Bahru General Hospital, my father summoned me. He expressed his wish to make a new will, revoking all previous one, and appointed me as the sole executor and trustee. This will I submit in his true last will and testament.
Dad, Mr. Sim here as you requested.
Mr. Haji Ghazali, do you wish to make a will?
Mr. Sim, she said she wants his estate is managed as he wishes.
Very well. I will start drafting all the documents now.
Your Honor, Mr. Singh prepared the will according to my father's instruction. The night in the presence of family and witness, the will was read aloud. My father got will gave his thumbprint of his own approval. Under that will, I was given the whole estate of my father.
Thank you, counsel. Does the defense counsel have any questions?
Yes, Your Honor. Mr. Ali, was your father able to speak clearly?
She was weak, but she aware she couldn't speak in a full sentence, but she mumbled agreement, and his eyes were open, and he understood.
Mr. Ali, you claim he understood the instruction, yet your father was unable to speak clearly. How can you be certain his intention were precisely what you interpreted given his weaker state?
I knew my father's wish. He trusted me implicitly. His mind was sound, even if his body failed him. His approval was undeniable.
Alright, that's all for my question. Thank you, Your Honor.
Defense counsel will now present their opening statement.
Much obliged. May it please the Honorable Court, I will present the defendant Hajah Alisha. We assert that the 1968 will is fundamentally invalid. At the time of its alleged creation on February 24, 1968, the deceased was unconscious, in a deep coma, and utterly devoid of testamentary capacity. He could not speak, understand, or approve any document. The only valid will is the one from 1961, which adheres strictly to Muslim law and appoints both the plaintiff and my client as executors, ensuring a just distribution of the estate. Your Honor, Hajah Alisha will now present her testimony regarding the wills.
Okay, you may proceed, Hajah Alisha.
Your Honor, I'm Haja Alisha Betty Kang. As the executor and trustee in this case, I must state truthfully that 1968 will is not valid. Can you tell me about Haji Ghazali's situation at that time? The deceased was unconscious because he was in a deep coma. He could not speak, he could not move, and he showed absolutely no sign of understanding or awareness. It is a physical impossibility that he could have given any instruction or approved any documents. Ma'am, do you know if the deceased ever made any will before 1968? Yes, the only valid will is made on the 1961, which complies with Muslim law, and the name both me and Ali as the executors. Alright, thank you. That's all, Your Honor, thank you.
Thank you, madam. You may step down now. Counsel, any witnesses for today? Mr. Singh, please state your full name and profession and the details about your involvement in the drafting and execution of the 1960 will for Haji Ghazali.
My name is Mr. Singh Kyogo. I am a practicing lawyer. On the evening of February 24, 1968, I was called to Johor Bahru General Hospital by Mr. Ali. He informed me his father wished to make a will. When I approached Haji Ghazali, I directly asked him if he desired to make a will. His eyes flickered open and he made a faint mumbling sound. Mr. Ali then interpreted this, stating that his father wanted his estate managed as he wished. Based on this, I drafted a will, including the appointment of Mr. Ali as the sole executor. I read the entire draft aloud clearly in English, in the presence of several family members. The deceased was physically frail, but his eyes were open. With assistance, I guided his thumb to make an impression on the document. He made no verbal objection.
That evening, in the deceased room, did you read the will aloud? And how was the deceased condition?
Yes, and I read it in English. The deceased was weak but conscious, and his eyes were open. I placed his thumb on the document with Mr. Abdul Rashid's assistant.
Did the deceased speak to you, Mr. Singh?
Yes, he mumbled, but I took it as assent.
Did he explicitly approve the contents?
He did not object anything, miss.
And what did he ask you to do after signing the will?
No, I wait for a request from Mr. Ali after the deceased death.
That's all, Your Honor. Thank you.
Is there any other witness, counsel? Yes, Your Honor. I would like to call the last witness, Datuk Dr. Ling Ling. Yes, please. Your Honor, Datuk Dr. Ling Ling, could you please state your full name and profession for the record?
My name is Dr. Ling Ling. I am a medical doctor and was the supervising physician in charge of the deceased treatment at the hospital in February 1968.
Could you tell the court when the deceased was first admitted under your care?
Yes, the deceased was first admitted on the 13th of February 1968. He had suffered a stroke affecting the right side of his body. He was also a chronic diabetic, which further complicated his condition.
So, what was his condition upon admission?
When admitted, he was unconscious. Although he appeared to respond slightly to verbal prompts, his responsiveness was minimal and inconsistent. He remained in this state until he was discharged.
So, when was he discharged?
He was discharged on the 18th February 1968 at the request of his family.
Was there any improvement in his condition during that first hospital stay?
Medically speaking, no significant improvement. Although he seemed to respond faintly to questions, he remained largely unconscious and was not in a position to make informed decisions or communicate effectively.
Was he admitted again after that?
Yes, he was readmitted on 24th February 1968.
What was his condition during the cycle admission?
He was in a coma and aphasia, meaning he had lost the ability to speak. In my medical opinion, he could not have responded to any questions or engaged in meaningful communication on the 24th.
So, just to clarify for the court, Would he have been able to understand or participate in something like making a will?
In my professional opinion, no. Given his state, comatose and apathetic, he would not have had the capacity to comprehend or approve the contents of any legal document, including a will.
Objection, Your Honor. The relatives present did not object when the will was read. Their silence, I submit, is consent.
Your Honor, both medical and factual evidence show the deceased was unconscious. The 1968 will cannot be valid. Furthermore, even if it were, it violates the Muslim law by giving all to a single heir. Thank you, Dr. Lily. No further question, Your Honor.
Consent must be explicit, not inferred from silence. The will first must be valid for consent to matter. After careful considerations of the evidence and submissions presented by both parties, this court finds that
the 1968 will, which the plaintiff claims to be the last valid will of the deceased, is hereby declared invalid. Even if the 1968 will had been validly executed, it would nevertheless be void under Muslim law. Secondly, the 1961 will is valid and admitted to probate. Thirdly, the conduct of Mr. Sim Telgok raises serious concerns and suggests professional misconduct. In addition, the creation of the 1968 will raised the possibility of forgery. The court directs that the case be forwarded to the public prosecutor for further investigation.
in light of the above, the plaintiff's claim is dismissed with cause, and the defendant's counterclaim is allowed with cause. Costs are to be paid by the plaintiff on a higher scale.
Heidi, this is the result. You need to accept everything. You try to distort your father's wishes to take everything.
Don't preach to me. You thought you knew the best? My father wanted me to have it all. He told me you just couldn't accept.